morning.
No cell phones. Off.
Turn off.
Right.
Oh, off.
Yeah, we should
So
take
just
off.
before we get started with Justin, I'm sure everybody knows about our wonderful, best kept secret about the Decedent team joining us.
Yes.
Came in Wednesday night, very excited. You probably saw all the publicity. It's all over the internet. We had full page in Neighbors, Business Monday. It's created a lot of excitement. They're bringing in about 30 listings.
Awesome.
Yeah, excellent.
And the least expensive is like 1.6 million, so I've been working all weekend signing releases and getting back and forth. So we're very, very excited because their target market is where we work, which is Gables, Grove, Old Cutler, Brickell, etc. And they are paired with the Jill, so it's the Jill Decedent team, and it's pretty exciting. We have Judy Decedent, her son Nathan, her daughter Kara, and then they have two agents that work with them, David Cavarokas from the architect developer family, and Natalie Iserman. They have Carolina Zuka is marketing. So Vanessa's training her, Moxie and all that, because she'll be on Moxie like we are. And then also Rosie Mendoza, the office administrator. And you see Rosie running around like the Energizer Bunny in all her little funny outfits. So we're very, very excited. I think it's great for everyone because we can really brag. And I think it's great for our listing presentations, buyers, etc. You know, that we now have the Decedent team, because they were like the two top producers at EWM, Riley Smith and Judy Decedent. They were right at the top of the awards page just 2 weeks ago. So we're very excited. And we're also excited that Justin Stivers has come to speak with us this morning.
That's a little
on
less
probate.
exciting.
Yes. He's a native Floridian, graduated from Appalachian State University in North Carolina and University of Miami Law School. He is local. He has a probate, strictly probate. That's all his firm does. And with the growing number of estates that we have in Miami these days, because there's so many people that have been here for years and years and years and kept their homes or their condominiums, that we're doing an increasing the amount of business with estate sales. So there's lots to learn, and that's why Justin is here.
Great, thank you, Charlotte. Yeah, I want to thank you, Charlotte, and thank the Gilmans. I don't see them here,
A
but...
client showed up.
Oh, okay. Yeah, John, and I've known John and his mom, Sonia, for a little while, and they made the introduction, so thank you all for having me here. Real quick before I get started, so make sure I am filming this, so I'll send it out to you, Charlotte, and if, you know, for the other agents who weren't able to see it, or if there's more information, you don't remember everything I went over, so you all can watch it. I know some people said they had to leave early. I have this enormous fishbowl. Quick funny story, I told my wife that I had a presentation and I wanted to raffle off some Starbucks gift cards, and I said I need a fishbowl, and I jokingly said it's for 5,000 people, so she told me literally enormous. So
You got rid of your goldfish?
I got rid of the goldfish, yeah. But if you have to leave early, or if you are interested in winning, you know, please leave your, I'll put this up front here. Just drop your business card in there, and then I have my cards, and then just if you want to take notes, I don't know if everyone has this piece of paper that I did. If not, I'll let you all pass it out.
Great.
I don't think Charlotte has it.
Oh, I don't have it.
Yeah.
Thanks.
Okay.
You don't have anything else?
No, I didn't bring it.
All right, so as I guess I'll just settle down. Well, I knew some people were leaving. That's why I wanted to get started before.
You said Starbucks or
No, everyone was ready to go. Charlotte, how long do I have till, just so I want to keep on track?
It's 45.
45 minutes? Perfect. Okay.
Computer screen there and then.
All right, so I want to keep us on track. We've got 45 minutes, so a lot to cover. As Charlotte said, my name is Justin Stivers. I am an attorney. I have a law firm. Our main location is downtown Miami. All we do is probate. So that's all I do. I don't do title, I don't do real estate, I don't do anything but probate. So that's the only type of law, only type of thing that we do. And I've been noticing it's a growing market, especially for real. I mean, it's a great market for an attorney, but it's a great market for realtors. And I've been noticing, given Florida, given the population, the demographic that is here, it's a really, I think, timely topic for you all looking for new listings and trying to maybe find a new niche. So this presentation, like I said, take about 45 minutes, and I call it Probate 101 for Realtors. So it's going to give you a kind of broad overview of what probate is. I have three kind of main points. One, to help you all find out when a property might need to go through probate. Two, just to give you all enough information about probate so when you go to a listing presentation, obviously, if you're not an attorney, you shouldn't be giving any legal advice about probate, but hopefully it's just enough information to help you kind of stand out from other realtors, give you a working knowledge of some definitions and what probate is. And then lastly, I want to give you all some tips and tools to kind of market for probate properties, because I'm guessing you all want listings. That's kind of the name of the game. And yeah, so we'll cover all of that. I normally like to go around the room, but just given it's a great audience, so thank you all for coming. But just show of hands, just so I kind of have an idea. Who's been a realtor for less than 1 year, maybe? Any newbies? Okay, a couple new people. Who's been a realtor for more than 5 years? More than 10 years? 15 years? 20 years? 30 years?
Yeah. 35?
40? All right, well, that's awesome. That's awesome. So for the newbies, the newer realtors, it seems like you've got a very experienced group in here, so that's fantastic. You all can really, I think, probably pick their brains to learn learn the business. How many of you all, just show of hands, has dealt with a probate property, either on the buying side, listing side? Okay, and maybe one or two of you all, briefly, what was that experience? Was it fine? Was it a nightmare? You can just...
I'm dealing with one right now.
Okay.
Listed the property, and within 2 weeks, the husband died. They're foreigners.
Okay.
So that triggered a whole, deal with the estate and all that. Now the sale fell through because the buyers could not wait until the IRS decided how much money they would be taxed.
Interesting. Okay.
And now I've sold it again, and it's being sold cash. Hope to sign the contract today. But the buyer is going to have to take it with a problem in the title that says that the money has to be in escrow for a couple of years until the IRS.
So it hasn't gone smoothly. So it has not gone smoothly. Okay.
Yeah.
Anyone had a smooth experience with probate? Okay, so it's all kind of ish a little bit. Well, as we go through the presentation, I hope you all will see that it doesn't have to be a headache. I think probate, even in the legal community, has kind of a bad rap as just being very taxing, just tiring, takes forever to close. So my goal is, because I want you all to see it, or I hope you all see it as an opportunity. If you all are newer, or maybe just looking to add something else to your practice, maybe see it as a niche to get into, that it's really not as difficult as maybe you might have heard. So to start, let's just go over, and if you all have any questions, please, just shout it out at me. And like I said, there's probably going to be a lot of questions. I'm going to try to keep us kind of on, within a broad overview. I know you guys will probably have a lot of, I've done this enough where I know there'll be a lot of more specific questions, but this is just kind of a broad overview. Okay, so we'll start with the key definitions, a couple key definitions which I have written there. But probate. So what is probate? I think the best way to think about it is probate is a legal process. So it's a legal process that has to go through the courts. There's a judge involved, there's attorneys involved, and you kind of think of it as whatever a person owned when they passed away. In this case, let's just say a house. If that property was not in a trust, and we'll touch on that in a little bit, it's going to have to go through probate. So you open a case with the court. At the end of the court case, the judge is going to sign an order, and now you all can sell the property. So the way to think, whenever you hear the term probate, I would associate it with courts, lawyers, and judges. For better or for worse, that's what you're going to think about when you think about probate. A decedent. So a decedent is it's just another word for someone who's died, someone who's passed away. So that's a term that we use once the person has died. It just sounds a little bit better than dead person. So we say decedent. We say decedent. An estate. So this is a pretty common word you all would hear. The way I think about an estate is sort of it's what the person who passed away, what their new name is. So let's say John Smith has passed away. The way to think about it is he is now known as the estate of John Smith. That's the way I think. It's kind of as if their name has changed. So anything that John Smith might have had, whether he had assets, a house, a car, bank accounts, whatever, or he had debts, credit card, hospital bills, anything like that, all of that is a part of his estate. So in probate, and we'll touch on this, but when you all are signing listing agreements, contracts, you're going to always use the estate of. Last will and testament. This is probably, most people are somewhat familiar with the concept of a last will and testament, or just we say a will, a person's will. It's a piece of paper saying who gets what when you pass away. So I could write it, and sometimes they're done by attorneys, sometimes you can get a form off the internet, sometimes it could be just a piece of paper that you write and you say, when I pass away, I want my house, my car, whatever, to go to my spouse, my children. There are some ways that you have to make it a legal will to actually be enforceable by the court, but when you think of a will, just think of who gets what after someone has passed away. Personal representative and executor. These are the other two terms that you all are probably going to be using a lot if you come across any probate properties. They mean the same thing. So personal representative and executor are the exact same thing. Different states use different terms. So sometimes people will come to me and say, yeah, I'm an executor. And I say, okay, in Florida, we use the term personal representative. So whenever, again, you're selling or have a listing agreement or anything like that, that person you're working with is probably going to be the personal representative. But you could also use the term executor. Just different states use different things. Those are really the most, I think. There's a ton of terms, but those are the key terms I think you all should have somewhat working familiarity with. Any questions? I know I'm like rushing through this, so if there's questions, please just stop me. Yes, ma'am.
Maybe it's too soon to
Sure.
ask this, but when we get a listing agreement, the personal representative and executor has the legal right to sign the listing agreement.
Yes, and I will
Okay.
touch on that. But yeah, that's correct. That's correct. Okay, so first kind of objective. So how do you all know when a property is going to go through probate? Just shout it out. Whenever someone, let's say, calls you a referral and says, hey, I've got, I think I've got someone who wants to sell this property. Their address is 300 Main Street, Miami, Florida. What's the first thing, one of the first things you all do?
Look it up.
Yeah, look at it. You go to the property appraiser's website most likely to try to figure out, are they the right owner? One of the easiest ways, and it might take a little while to pass all of these out. I probably should have done it before, but I'll just leave them up here because it's going to be too noisy and whatnot to pass it around. But I've got a couple different examples, and I'll leave them here. You can grab them on your way out. But so one of the first things, to determine whether or not a property that needs to go through probate, is look at the property appraiser's website. Okay, and in this example, the owner is Maria Pichardo, and then it says EST of. So what that means is estate of. In this case, whenever you see this, I would say 99% this is going through probate. And this one did. This is one we did. If you see, this is kind of the easiest way to know whether or not a property needs to go through probate. If you look on the property appraiser's website and you see estate of, this is going through probate. And this is one of the easiest ways to kind of identify whether or not, and it should, again, if someone tells you, hey, I've got a property 3000 Main Street, and you see this, your mind is, is going to shift a little bit, and you're going to start thinking, okay, this is probate. What are my next steps?
Right.
Yeah, okay. The other common one is, and this is another one that we did,
Excuse me.
is, yes, sir.
Just what triggers that at the property appraisers? Vital statistics being reported that a death has occurred?
Yeah, that's a good question. It could be a series of things. Sometimes vital statistics will alert them, and I think they probably have people that, you know, kind of scour the records to see if the death certificate was filed. It could be that, it could be a mortgage thing even as well. Sometimes the mortgage company, if they're not, you know, maybe it had gone, in this case, this one had gone into foreclosure because the person passed away, so there were no one was paying the mortgage. And I think that might, I actually don't know exactly how they get this first information, because sometimes it would be, you know, maybe a couple of months before they're alerted, but so it could be a series of things where sometimes, you know, the family might alert if they're not really sure what to do.
It could be also the court case gets filed, so the
Right.
number.
Sometimes, but this was like this before we even had a court case. So it is, that is one of the ways that it could be. Good question though. This is another common example. This one's a little bit more tricky, I guess. So this one, the property was owned by the estate of Jesus Silva and Maida Silva. So it was owned by two people. Now, Jesus was Maida's father. They owned the property 50-50. Maida didn't know that she couldn't sell the property because she only owned 50%. And the only way that she was able to sell this property was to do a probate for her father. So this is pretty common here where, and I don't want to get into deeds too much, but a lot of times if you just own the property 50-50 with somebody else, an exception is the spouse, but let's just say you and your brother, you and your sister own a property 50-50. If that one of them passes away, now the estate owns 50%. And even though you own 50%, you can't sell the property until it goes through probate for the other person. Yes, ma'am.
But what if you have what is it, that the estate in common or right with survivorship?
Right, so there
goes to the other person.
Yeah, so there are exceptions. So there are, you know, and like I said, I'm not a real estate attorney, but there are exceptions where, you know, you could have a deed as a joint tenant with right of survivorship, might be one that you all are familiar with. There's another one called an enhanced life estate deed, where it will avoid having to go through probate. But generally, if the property appraiser has the estate's name on there, that means it's going through probate. That means that the deed didn't have it done that way, where it would avoid it. Yes, ma'am.
If that person only had that one child, does it still have to go through probate? Because if they're
Yeah, she was an only child. She
Only
was an only
child,
child.
okay.
Yep.
So it still has to go to probate?
Yep. It went through it's in probate right now. It's in probate right now.
Now, I often see a family transfer in the tax roll. What does this mean? It means that automatically it goes to the interfamily.
If there's I think.
I haven't seen this before.
So if there's another example is this trust, okay? So this is one way, and a couple of us were speaking, just generally speaking, a will on its own does not avoid probate. And that's a big misconception, that if you just have a will and that's it, it's still going through probate. So I get probates all the time where, you know, dad left, you know, his son and daughter 50-50, everything was spelled out, you know, my son gets 50% of the house, my daughter gets 50% of the house, it's still going through probate. One way to avoid that, and this is another thing you might see, in this property, it was owned by Ms. Rodman, and then it says TRS for a trust. In that case, you're avoiding probate. I would say this is if you're speaking with someone and they're wanting to avoid probate, a trust, it doesn't work for everybody, and that's a whole, you know, a trust is a whole nother conversation, so I don't want to go down the rabbit hole on what a trust is, how to do all of that. But a trust will avoid probate if done properly. So this is probably the most. A trust is a little bit more sophisticated. There are not generally you have to have the mortgage has to be paid off before you can put the property into a trust. There are some, you know, so a trust doesn't work for everybody. I would say, you know, between the trust, the joint tenants with right of survivorship, those are the most common ways people avoid probate. But these are, you know, I would say these, at least in my world or in your all's world, if you're looking at getting into probate and you're trying to determine whether or not a property is going to go through probate, look at the property appraiser's website first. If you see the estate of, chances are it's going through probate or it's in probate.
How long is the probate process?
I'm gonna touch on that as
Okay.
well. Yeah.
But, okay, Justin,
Yes,
so
ma'am.
the two things to avoid probate would be have a trust
Mhm.
or joint tenancy with right of survivorship.
Yep.
Those are the only two things.
There's I don't know if you all use the term Ladybird Deed. There's a type of deed called life. It's sort of like a joint tenants with right of survivorship, but again, it's another type of deed. In my world, we call it a Ladybird Deed, and it's sort of so I could put my, let's just say, my daughter on title, and I say when I pass, the property automatically goes to her, and that will avoid probate. So a rule of thumb is the deed is going to trump a will. Because I get this a lot of times where I had a call last week where a gentleman, his mom had passed away, and he goes, yeah, my mom left me the property. She left me the property in the will. The will says Joe gets the property. Unfortunately for Joe, his mom had did a quitclaim deed to his two daughters, to her two daughters before she passed. So the deed now showed that his two sisters were the owner of the property, but the will says he gets it. The will is meaningless at this point. The deed wins. The deed wins. So the deed is always going to beat the will.
So how does the title have to be written as for that to work?
Well, they wrote it just as a normal deed. It didn't have anything to do with probate. It was just a normal quitclaim deed. So it was just as if the mom just left the property to her two children. It was just normal. Does that make sense? The will is irrelevant at that point.
How does the title of the property need to read?
It's as if you did a normal closing. It's as
Right,
if,
so
Yeah.
it's $0.
yeah, just a normal.
Family.
It's just a normal deed. So
Right.
when you go to sell a property and someone buys it from you, you do a deed, right?
Right.
It's the exact same thing. It was just a normal deed. It was a quitclaim deed. But I don't have like the exact wording of like what a quitclaim deed says, but it's just a quitclaim deed. Yes, ma'am.
Question, for the Ladybird deed to be effective, does that person, the beneficiary, have to be on title?
Yes. Yeah. Okay, so there. I don't want to go down too much into deeds because that's a whole nother topic. But I guess the main takeaway is I want y'all to be able to locate when a property is going to go through probate. And yes, there are some ways to avoid probate, and just generally, it's the way the deed is written and it's a trust. But that would be if you're dealing with that, if your clients are asking how to avoid probate, that's another conversation. This is really geared at you finding the property and you know it needs to go through probate. So let's say that you've located this property, you see that it needs to go through probate, and you're getting ready and you're going to go have the listing presentation. You're going to go speak with the potential seller. There's a couple key questions that you all want to ask to make sure you're speaking with the right person. Because the last thing, and I've seen this before, the last thing you want to do is be speaking with somebody and find out they don't have any right to the property anyways. And then you waste your time and you get a listing agreement and they can't sell it. And I've seen it. So two key questions you want to ask. First is, was there a will? And can you get a copy of it? So obviously, and again, I don't want to go back down the deeds part of it, but if there's a will and it says that Joe gets the property and you're speaking with Sarah, well, Sarah might not be the person you want to be speaking with. So you want to ask, do you have a will? And if they say yes, you want to say, do you have a copy of it or can you get a copy of it? Reason being is, I've seen this, not a lot, but Joe might be, 5 cousins removed, and he says, yeah, but he said that he was going to leave me the property. He wrote it down on a piece of paper. I think he had a will. I know he had an attorney. I just don't know where that is. Well, that would kind of trigger something in my mind that he might not be telling the truth. And a lot of times people ask me, they go, well, can you find the will? So there's no master will database where I can just, find out who had a will. But that's a common question. I mean, a lot of people think that because, again, like I said in the beginning, a will could be written on a piece of paper and stored away in someone's house, and so So if a person tells you a will, says that they have a will, always ask, do you have a copy? And if they don't, say, well, can you get a copy? And then they might not be lying, give them the benefit of the doubt. But if they, kind of retract a little bit and they're like, well, it might raise some red flags. You want to find out, is this person, telling you the truth?
Does the will have to be witnessed, just so you know what you're looking at?
Yeah, there's requirements for a will. I would say, though, at that point, I wouldn't advise you all to, determine whether or not you think the will is valid. You're probably going to want to bring in an attorney at that point, but just find out, can they get a copy? I wouldn't suggest or recommend that you determine, is this legally valid? Yeah. Second question, so if they don't have a will, or even if they did, ask what's your relationship to the person who passed away? And again, I'm just giving you worst case scenarios. You want to make sure that this is the right person you need to be speaking with. And rule of thumb, and there's a hierarchy as to who gets what, if there's no will. So if there's no will, first the surviving spouse, and then the children, and then the parents, and then the brothers and sisters, and then the grandparents, and then it's the aunts and uncles, and starts going down. And if you're speaking with, the aunts, sisters, brothers, boyfriend, he's probably not the right person. Is it impossible? No. We just got a referral from somebody, and she's the second cousin, and literally we did air search, all of this. She's the only living relative, so she is entitled to the house. So it's not impossible. It's just that's very unlikely. So you want to make sure that you're speaking to a person who's in close relationship. A son, a daughter, a spouse, somebody. And if not, again, I don't think it's your all's job to determine whether or not they're a right person. I just think it's a good idea before you, go down this path of getting the listing agreement and everything signed. Just make sure you want to make sure you're speaking to the right person. And again, if this is a potential client and then you're going to probably go to, see your attorney or whoever, you can have enough information to tell him or her, hey, this is who they are, and then you all can kind of decide how to proceed from there. So if you're getting a listing, or if you're going to a listing presentation, ask if there was a will, ask if they have a copy or can get a copy of it, and then ask what the relationship is to the person who passed away. And we already touched on it, so again, I won't go through this again, but yeah, a will in and of itself is not going to avoid probate. So, all right, so you've spoken with the person. They're ready to go. What are the first questions that this person is going to ask you about probate?
How long does it take? What's the process?
How long does it take? What's the cost? That's pretty much that's what they ask me. My first thing. I always say it's sort of like in your all's world, a simple closing could be 30 days, close, no problem. That simple 30 days turns out to 6 months, 7 months. And not really through any fault of your own. It's just sometimes, the title report doesn't come clear or whatever the case may be. Sometimes it takes a little bit longer. So I'm always hesitant to say, hey, a probate is going to take this long because anything can happen. And if Bob, the second cousin from California, comes in and says, hey, I've got a will, well, that's going to mess everything up and make it a little bit longer. But on average, just to kind of like hang your hat on something, there's another key thing to ask is when the person died, okay? And without going into the legal part of it, that's a relevant number. The relevant number is 2 years. If the person died 2 years ago, okay, I would say on average, you'll be able to sell that property in about 2 months. On average. It could be a little bit longer, it could be a little bit more, but if the person died 2 years ago, it's probably going to be about 2 months. If the person died recently, within 2 years, it's probably going to be closer to 5 months. And the reason being is that, again, this is just for fun, I guess, but there's a 3-month period if the person died within 2 years that the courts make you wait before you can sell the property. So
Don't you advertise?
What's that?
You advertise.
So,
Don't you, for any debts?
Yeah, exactly. It's called a notice to creditors, and there's a 3-month period where if someone passed away and she owned, she had outstanding credit card bills, maybe insurance didn't cover her medical bills, they have a 3-month period where they have to come and they have to file something with the court. They tell me, and then we deal with, you know, the debts. But they have a 3-month window, so the court will not let us, usually not let us sell until that period has expired. So that's why, you know, if someone tells you, hey, I can get you this property sold in 30 days, no questions asked. Well, if the person has died within 2 years, I would run from that person. Yeah.
Question for you, what if in the lesser scenario where someone was on Medicare, Medicaid, you know, they're not gonna have any assets, right? Do you still have to do that 3-month period, and still do that advertising notice to creditors?
Well, in that case, they probably don't have a house, right?
They don't have anything.
Well,
Well,
then
they may have a house, but they may not have anything else. They were Medicare, Medicaid, and a hospital.
it doesn't matter. Asset has nothing to do, like, if someone died within 2 years, you're doing that 3-month creditor.
It doesn't matter.
Doesn't
Okay.
matter. Doesn't
Okay.
matter. So yeah, so I would say on that, so if your client asks you how long is this gonna take, if they died 2 years ago, rough estimate, let's say 2 months. If they died within 2 years, let's say 4 to 5 months, more or less is how long it's gonna take. Now, the next question you all are gonna probably ask is, well, when can I list this property? Or when can I get when can I sign the listing agreement? Well, when it comes to the listing agreement, I would advise, you know, speak with your attorney, your probate attorney and whatnot, and just make sure you're speaking with the right person, right? Because you don't want to sign up somebody who doesn't have the authority to sell the property. So who does have the authority to sell the property? It's the personal representative. The personal representative is the person appointed by the court. It's usually the personal representative is either going to be named in the will. The will might say, you know, I want my son to be personal representative. Or if there is no will, the personal representative is usually the relative, the closest living relative. So again, the son, the daughter, the spouse, something like that. Once you know you're speaking with the right person, here's how I would advise. This is the language I would put for the listing agreement. I would put their name, John Smith, as proposed personal representative of the estate of whoever passed away. Okay? And here's what that, I know it's like a long title, but here's what that basically means. John Smith is going to become the personal representative of the estate of whoever died. He's not quite the personal representative, but he's going to become the personal representative.
Why don't we do it that way? Why not just personal representative?
He's not personal representative yet.
Even if he's on a will?
He's not personal representative until the court says he is.
Gotcha.
You're gonna
Okay,
get
understood.
you're gonna get an order from the judge saying that he or she is personal representative.
Understood.
He's not personal representative until the judge says he is. Okay?
This is before the judge says, you say proposed.
Exactly.
Okay.
And this is the listing agreement.
Yes,
essentially.
sure.
This is the listing agreement. Yes, ma'am.
Wouldn't it be prudent for us as realtors to, from the beginning, orient them as to who their attorney is going to be, and then get in touch with that attorney and
Yeah, sure.
do all that to find out who the real person is?
Yeah, and I'll touch on that a little bit as well. But yeah, I would absolutely, if you're gonna, I'll touch on that. And I'll touch on that in a second. But yeah, absolutely. Okay, so now now you've got the listing agreement. All right, the person is signed up. Their proposed personal representative. When can you all go out and start marketing and selling it? What I always advise is let's wait until that person is named personal representative, because they can't do anything until they become personal representative. So on our end, on the attorney's side, it usually takes us about 30 to 45 days to get them appointed as personal representative. And that's not from my first conversation or the attorney's first conversation. That's from when we've got all of our documents from the client and now we've filed the case. It's going to take us about 30 to 45 days. After that person has become is appointed personal representative, I say go for it. Okay, you guys can go ahead and try to, you know, market, sell the property, because now you have a personal representative, and when you get the contract now is going to say John Smith as personal representative of the estate of. And at that point, John Smith has the authority to sell the property. Before he was personal representative, he can't sell it. But now that he's personal representative, he can sell the property.
Got it.
The personal representative has to provide a document to the realtor.
Yeah, it's an order. It's what's called an order appointing personal representative. It's a
Okay.
document from the judge, signed by the judge, saying that
Okay,
person is
so we're
personal
looking for that.
representative. Yeah.
How long
But it-
does that take to get?
30 to 45 days.
45
30 to
days.
45 days, yeah.
But at the point of personal representative, the title to the property still has not passed on to the heirs.
Say that, sorry, say,
At the point of personal representative being appointed by the court, the title to the property
No.
has not passed
No.
from the deceased to the heirs.
Right.
no, the personal representative is just the person authorized to act on behalf of the estate.
Now, from that point to when the title passes to the heirs could be how long on average?
Same time frame, depending on when the person died, it could, from the time the person was appointed personal representative, it could be 1 month to another 4 months. Yeah.
So it sounds like we need to get you or an attorney on board the moment someone dies, to get that going if they have anything.
Yeah, so the Realtor, again, I'll touch on this, but you all are probably gonna come up, you're either gonna find the property at the very beginning, just in your normal prospecting, or, you hear someone passed away and at that point, then you're gonna probably bring the attorney on board, or you all are gonna get the listing from the probate attorney. Because at that point, we're going to you all might not have known, our client hired us because they know they gotta go through probate. And when we're doing the probate, we know they have property, so we need a realtor to sell the property. So we would have all of that information. So it depends on when you all come into the situation. Yeah.
So, quick question. The property can be sold before the probate closes.
Yeah, so that's a great distinction. So the probate does not end with the sale of the property, not necessarily. So you all, my estimate that I gave you all, either 2 months or 4 to 5 months, that's when you all get to sell the property, you all get your commission check, go on to the next one, right? But the probate's gonna continue. So I'm still gonna be, or the probate attorney is still gonna be working with the client.
The family won't get their money until it closes.
It depends. It depends. Yeah, it depends. But that's a very technical thing. I don't.
Sounds like
Yeah.
it's on its own.
Now,
Yeah.
that wouldn't work if you get a mortgage, that would only be work if it's a cash deal, right?
What wouldn't work?
No, it doesn't.
If you are going through probate, you can still go through the mortgage and no problem, because the funds would not go to the family, they would go in escrow.
Well, the funds. Again, I don't do real estate, so I'm not really. But the funds are going to pay off that original lender, so they're not going to be coming to. We're not going to be dealing with that.
Right, but that's my problem, right now, the banks are, if it's sold with a mortgage, the banks will not allow the funds to go into an escrow, even if it pays off.
No, what
whatever
he's
it
saying
is.
is the mortgage will be paid off. The
It
balance
doesn't
goes
matter,
in
it
escrow.
doesn't matter, if the mortgage is paid off, whatever, in this case, it's property.
I don't know. We sell. I mean,
But it's a foreigner also.
we
It's a
sell
foreigner.
property. I mean, we sell properties that have an outstanding mortgage all the time through probate. So I don't. I'm not sure that specific one. Yeah, you got a question?
No, I was just gonna comment on her, that the mortgage gets paid off at the time of the closing, and then the money gets
Right.
put into the attorney's escrow account that's probating.
Yeah, the proceeds would come to us, but the mortgage would be paid off separate.
With the person that's buying, if the person gets a mortgage, that's the problem, not the outstanding mortgage, it's the one, the party
buyer
buying,
taking a mortgage.
would have to have cash to pay off.
No, they can get a mortgage. They can get a mortgage.
That's the reason I couldn't close.
They can get a mortgage. Yeah.
Because it's
I don't know.
Could be the lender.
Yeah, it could be the lender.
Remember, it's FERPTA, so there are other issues involved there.
It depends on the lender.
So all right, so just to, because I think those are really, those are all great questions. I think the biggest thing so the listing agreement and the sales contract, you want to make sure you're putting them as the proposed personal representative or the personal representative. And the reason you're doing that is not necessarily because the court needs to see that. You're doing it really to protect your client. Because, a lot of title companies, I've seen them, you've got your as-is contract, and it might just say John Smith, right? It might not say as him as personal representative, but the title company knows it's a probate. They know what's going on. My concern is that if the contract falls through for whatever reason, John Smith could potentially now be personally liable because he signed that contract as his own name. And I don't want, he's doing kind of a service to the estate, so I would rather the estate be liable and not him personally. So it's really, you're adding that language to protect the client.
So if you have an original listing like she had, that was John Smith, and then John Smith dies in the process of selling the home, would it be wise then to amend the contract to? state
Well, you'll
that
have
the
to,
estate
because
of-
you would have to. Yeah, you'd have to, because John Smith can't sell the property because he's passed away.
But that would be, and in the case you have a personal rep that hasn't been appointed, you would still do the same thing, right?
Yeah, in that case, so that property couldn't be sold until you went through the probate process, got approval from the court, and did everything. And then you would rewrite the contract,
So
because
you
now
have
it's
to take
somebody
it
else.
off the market?
No, you could still leave, I mean, you could still leave it on the market. I mean, you have, it's just depending on how much the buyer wants to wait. I mean, it's how, at that point, it's really just the buyer.
Just say subject to probate.
Yeah, I mean, that's another thing I always put in there is, you know, I don't like to, because again, that 2 months, that 4 to 5 months, it's an educated guess, but it's not set in stone. But if you put in there, you know, this property will close in 4 months, and it doesn't, you know, I always like to put language in there that says just something simple, subject to court approval, you know, and then you kind of protect them.
And then the deed can be signed by the personal rep.
Exactly,
And
yep.
it's called personal representative.
The personal
deed.
representative deed, yeah.
Got it.
Yeah, so the personal representative is the one who's gonna sign all the documents. Yes, ma'am. Okay. Okay, so then, you know, then cost, just real quickly, just because that's something, it's sort of like everything, you know, fees range and whatnot, and you have some attorneys who will get paid out of the closing, you have some attorneys who charge hourly, some of them will charge a percentage of the estate, some of them will charge a flat fee, so it varies. So I'm always hesitant to say price, but I would say on average, you're probably looking at on the low end $3,500, on the high end $10,000. That's depending on the estate, but that's just, you know, so you have an idea so that the client's not thinking this is going to cost me $100,000 to sell it. But that's a range, more or less.
What cost of the
3,500 to 10,000.
Yeah.
But that's pretty approximate.
Yeah, that's.
We could go higher to get
I would say, you know, it's kind of I would advise, don't give that information necessarily to the client, because then you've kind of boxed whoever's going to do it. It's sort of like, you know, if I have someone who wants to sell a property and I say, oh, I've got a realtor, they'll do it for 2%, you're gonna be kind of pissed off at me. Why I do that. So you know, but if they're thinking $100,000 or something, you know, just tell them, hey, I'm not sure, but I don't think it's gonna cost that much. Speak with the attorney, give them a couple names of different attorneys to vet. Yes, ma'am.
Do you have any experience with when you've got the buyer and inspections are done and everybody's happy with that, and then I really had one of these where, it hadn't been through probate and it had to be. And it took about 5 months to do that.
Sure.
In the rainy season with the handyman special. And the seller had already contributed several $1,000s to the roof and other repairs. But when it rained, the roof fell on the floor. So the buyer's like, I didn't buy it with my plaster on the floor, and the seller said, I've contributed once. What's the?
Start over.
That's a little outside of my scope of what I deal with. I mean, yeah,
It doesn't have anything to do with probate.
yeah, that's a little bit outside of my. I mean, so yeah, I don't really want to give you an answer on that. That's not something I really deal with.
What we did, we were very lucky. We had a very sophisticated buyer, and the seller gave them the insurance.
Gotcha. Okay.
In that.
Yeah. All right, so shift gears a little bit. We've got a couple minutes left, so I want to leave if there's any additional questions. All right, so now you found the property, and you've given them some useful information. And again, I think that just by, I hope, you know, this is useful, and it's probably a little bit overwhelming, you know, just because a lot of terms maybe you haven't heard before. But I think if you, just with those couple of definitions, or just having, you know, a little bit of an idea, you're really, a lot of realtors don't know. They don't know, or there's a lot of misconceptions out there, so I think you'll be able to stand out when you go to the listing presentation. Again, don't try to practice law, don't try to tell them, you know, you gotta file this, you gotta file this, you gotta do this, you know, but just have a working knowledge of just some key definitions and more or less about the process, how long it's gonna take and whatnot. So like I said, you're gonna come across probate usually one of two ways. The first way is, and I just got one, a probate 2 weeks ago. A young realtor was knocking doors. He just happened to find a lady cleaning out the house. Her, I don't remember the relationship, but he had just passed away. He didn't know what to do. He contacted someone who contacted me, and now we're helping him do the probate. So you might find it door knocking. You might find it calling expired listings. There are, I know you all can probably buy leads as well, or you may, unfortunately, this is people pass away. That's when, I get called, and so you might come across someone who's passed away. That might be an opportunity to help somebody with a probate property. Or you might, I think probate attorneys are fantastic referral sources for you all. In my office, we're opening between 10 to 15 new probates a month. Not all of them have real estate, I would say a lot of them do, but not all the time do people want to sell them. Sometimes, they want to keep them as investment properties, or it's the family home or whatnot. So they're not all going to be sold. But in Miami-Dade alone, there's about 100 new probates filed every month. Okay?
Wow.
There's a lot of potential there. And I did a just brief search over the weekend. I think there were 60 filed so far in March.
Wow.
So again, not all of them have properties that you can sell because maybe the kids want to keep it or whatnot. But it's a great little niche that I don't think there's very few realtors who, I guess, quote unquote, specialize in probate. So I think probate attorneys could be great referral sources for you. So how do you reach out to probate attorneys? It's sort of like anything. It's like me. You all are in relationship businesses, a relationship business where you just kind of foster the relationship. I don't think there's anything wrong with buying lists, buying leads. I mean, I get emails all the time from realtors saying, hey, we can help you sell this. If you're going to do that, and I buy lists myself, when I'm marketing for stuff, I don't think there's anything wrong with that. But be unique and put a little bit of time into your email. For better or for worse, attorneys are overly just annoyed with bad grammar. It's just something we're trained. So I spot missed commas and whatever all the time. It's awful. It's painful. My wife hates me, but it's just if you're gonna go that route, I think it's it's a numbers game. So chances are, but just kind of differentiate yourself. And one thing that I always tell realtors who I'm working with is, because I don't do title, because I don't do closings, once I've got you the order saying that you all can sell the property, I don't need to be on every single email from all the realtors, from all the mortgage companies. I mean, especially, if I've got 10 or 15 cases that all have real estate each month, that's a lot of emails that I'm sifting through. That's just maybe a pet peeve of mine. But, if the attorney's not helping you with the title, which, in my case, I'm not, I don't need to be on all of that. And then just a couple closing things. Probate by its nature is a difficult time for a lot of people. Yes. So they've lost somebody, and you are helping them sell the property, but you don't know if this was mom who just passed away and she had been sick or whatnot, and this is the family home. She can't keep up the mortgage. She's got to sell the property. So it's not. I'm sure you all are, when you go into listing presentations, you are caring, you are empathetic, but just know that this is a little bit more heavy than your average, listing. So you want to really show empathy and go kind of out of your way, do a little bit extra on these types of things. And when you are working with an attorney, I always say, let's be a team. We're on the same side, because especially if you in this instance where this person was door knocking, she's an elderly lady. She didn't know the realtor. She didn't meet me. So she's already kind of feeling vulnerable. She's not really sure, people get unfortunately taken advantage of. And so she was a little bit nervous. So the realtor and I worked very well together. I said, hey, I think you should give her a call. He said, I think you should. We just went back and forth. So whether the referral is coming from an attorney or somebody else, go out of your way to just really make the person feel at ease. Because again, this might be the first time they've ever lost somebody. This might be the first time they've sold a property, been through probate, so it's potentially difficult. But if you all have any questions, I do have cards up here, and my email is still the same, but I changed it to a much easier one. It's justin@probatefirm.com. So I'm happy to answer any questions. I'll send the video around. Yes, ma'am.
Okay, so 90 days for creditors, and then you get the bills.
Mhm.
How do you know what's legitimate and what's not?
So,
Good question.
I object to all of them.
Oh, okay.
I object to all of them, not because I am being like, just whatever. There's a process that they have to show me that those bills are legit. Most likely, well, hospitals, they kind of inflate their bills a little bit. But credit card companies, generally, it's very itemized. You spent $2,000 at Home Depot and you can see what it was. But they still have a process that I object to it, and they have to respond. And then that's kind of in my, wheelhouse at that point where I fight most of these creditors.
Interesting.
But yeah, I object to everybody. I object to all of them. Yeah.
Interesting.
If the personal representative decides not to sell and keep the property, how does that work? Did they automatically get a new deed is created and now just they appear in the deed?
Yeah, if there's multifaceted question, but if there's just one person and that's the only person inheriting the property, yeah, that's the new deed. They are the new owner.
And you draft the deed or
Well, yeah, we do essentially.
You do it.
Yeah,
Okay.
because it's a special personal representative deed that is within my
and it's
wheelhouse.
recorded
Yeah.
with this?
And that's recorded. Yep.
Okay.
Yep.
So when you have the listing and now it's pending, you have a contract. On that contract, do you put, subject to court approval?
I do. Yeah.
Like in the term,
in the contract, yeah.
Yeah.
In the contract, I
'cause
do.
you put a date on there, but.
Yeah, I would say, put out 4 months, more, depending on the situation, but put out 4 months more or less, and then put in there subject to court approval, because it generally is gonna have to be approved by the court. Yeah.
In my experience, it's not, if everything's ready to go, it's not that long.
Yeah, sure.
You go before the judge like every Thursday or something.
Mhm.
They're
Yeah, they
judges and they approve it, and it's not always that long.
Yeah, again, there's a whole different situations, but yeah, so like I said, I want to be overly cautious just in case, but yeah, sometimes, again, depending on when the person passed away, and depending on the situations, again, not to go down a rabbit hole, but if the property's in foreclosure and there's like immediate urgency, we need to sell this property because the property's gonna be sold, we'll go into the court, tell the judge, look, we can't wait 90 days, we need to sell this right now or the property's gone. And then, it's a whole nother situation, but yeah, there are situations when we don't have to wait that 90 days, but just to be safe so that, we don't think we can get it done in 30 days, but yeah. Awesome, and so I got a couple Starbucks cards to raffle off. Does everyone put their card in here? If not, yes, ma'am.
Carolina just put your name on.
And oftentimes you find these,
Set up a meeting where
You could look on the
your card.
Well, are you talking about Miami-Dade or? I think it's Miami-Dade dash.
When did you get in? I didn't see that.
Yeah, if you know the case number. Okay. I've got some business cards over here, but my email is justin@probatefirm.com, and I've got a couple other cards. Okay, that's fine. All right, do I have everyone's cards just so I can?
One second, just, did anybody else have a question? No, okay.
Yeah, I just want to be respectful of y'all's time. I know we have
I
till
saw
11, so.
another
Last
hand.
question, but somebody's asked me, her husband passed away like 8 years ago, a step-up basis? You heard this?
Yeah, it's a tax question. Yeah, that's a tax question. Yeah.
Is there any place where we can find ourselves those recorded probate?
Yeah, there's she was asking me the same question. You can go to the I don't remember the exact website, but I think it's miami-dade-clerk.gov. And then if you know the case number or the person who passed away, you can search for for the case.
But
Yeah.
if you don't have a case number, you can't find the information on it, 'cause-
If you know the person's name, you could.
oh, with the name
With
you
the name you
can,
can.
or
But
without.
there's not I think what they're trying to get okay, all of these are going into probate.
Oh, to find the property?
Right.
I know people, I don't know how to do that, but you can buy that list. I only know people do that because I get email blasts. So someone's
just
getting
getting a list.
the information, but I don't know, the way that I would do it, it would take you days to go through every case, look up the
Right.
specific document, to find the property, to find out so you probably wanna buy it, or buy the list or.
Yeah.
All right, so you wanna help me and just draw 3 for me? We all like coffee, I think, or tea or something.
Okay.
There we go.
Lily Diaz? Thank you. Milana. And Steve Weiss. Thank you, Sean.
That's it, thank you, Justin.
Thank you all.
If he's able to.
Email me, I'll have my,
Yeah, oh, wait a second, okay, everybody.
Right, going to call you on there or something?
Okay, Vanessa has an announcement.
Today's last day to RSVP for the Lunch and Learn with mortgage, title, and home warranty. So it's not a one